Yes, Mr. Simmons.
Good morning, my lords. My lords, I was I think, still on ground one and floor analysis, and there are a few finishing up points on that, and then I propose just to briefly deal with ground two in a sort of COSMAR submission of my own friend.
Yes.
And then briefly canter through the grounds to the extent that you need just the sort of headline submissions following on from that. Then on to ground two and deal with the response notice points at the same time. So that's the route map. And I promised my learned junior I'll seek to leave him at least half an hour to deal with the clause 10.5 as well. So that's the plan.
Yes, very good.
In terms of, sort of some finishing off points then, Payman and Jani, it may just be of assistance for your lordships just to be taken to the pleadings to see what the pleadings were before the court. You remember the debate about precisely what was live and wasn't live yesterday, and Wellington and I have identified, I think, that there's mention of the pleadings and amendments to the pleadings, which is probably the clearest place we get it from the background facts summarised by Lord Justice Stevenson. So if you want the reference in your bundles, if you don't already have it open, it's in folder 1, I think, is Payman. It's behind tab 14, and then the specific continuous pagination reference is at 337, and internal page reference 475, and then the discussion of the original statement of claim and the amendments made to it are then discussed between, in effect, the substantial paragraph between C and E. So you may just want to take a few moments just to read that to see what's said there about what was in effect said.
Yes, the plaintiff was actually a party to the second impersonation, wasn't he?
I'm not sure if that's strictly speaking.
Wasn't he? I thought he went along to the second meeting.
I may need to check that point, but
right.
Yeah.
With his daughter.
Yeah.
The daughter, I think.
And the plaintiff.
Yeah, I may need to check, but yes. I think the point we were just seeking to draw out was there was amendments of pleading to plead rescission, and it looked like it was rescission on the basis of certainly in relation to the misrepresentation, the impersonation. But I mean, little 3, there's also reference, isn't there, to because of the first impersonation and all the defects in title.
But it wasn't said to be a representation made to the plaintiff, and indeed if he went to the second meeting that would have been a tough one, but misrepresentation to the landlord,
exactly,
which rendered the title defective.
Exactly, it's a third party, yes, exactly. So it's an unusual set of circumstances in that respect.
Yes,
but it's an issue which goes to the question of the title, not a misrepresentation case as between the plaintiff and the defendant in that sense.
Yes.
Yeah. So I'm not sure if that takes much further in the sense that hopefully it helps you to see what was before the court in any event. I think probably the reasoning in the court appears to be principally on the basis of the sort of common law rescission type concept, but there does also appear to have been, even if not expressly articulated, the possibility for that to be said to be a contractual basis as well. I think probably I can't put it any higher than that. I'm not sure if that takes things much further, but anyway, I thought it may be of assistance for you to see that particular passage if you haven't already considered it.
Yes, thank you.
Moving on in relation then to a further point, I just wanted to briefly draw out of the judgment of Lord Justice Slade at page 501C or continuous pagination, I think it's 363. So this is a passage. So you see, if you just scroll back, we'll go back up the page. You see at 500, there's discussion about endorsement of the general proposition at the bottom between G and H, having referred to Kendall and Hamilton, Young, and etc. And so, in effect, H is the endorsement of the ratio, if you like. And then there's a few observations about the practical consequences, which the judge then makes following, which is it concludes then at C at the mark passage, where he refers to the importance to have in mind the two doctrines of election and estoppel alongside each other. And in particular, you see the passage, if on the other hand, A has not acted to his detriment in reliance on any such apparent election, justice would not seem to preclude B from sheltering behind his ignorance of his legal rights. These brief observations may perhaps highlight the distinction between election and estoppel. So really that, in our respectful submission, is a further endorsement of the key difference. And you see that concept and that principle endorsed at a high level in Evans and Bartlam by Lord Applicant, obviously one of our best known criminal lawyers. And it's worth just briefly turning back to Evans and Bartlam. And that is behind tab 7, should be in the same file, hopefully, as you already have open, page 473. Obviously, it was one of the authorities which was persuasive on the Court of Appeal, and indeed found by them to be binding on them in Claimant and Jarney. Lord Atkin's speech starts at page 476, and then there's the passage at 479, which is referred to, I think, by Lord Justice Stevenson in Claimant and Jarney, but is also echoed in the observations of Lord Justice May, which I just took you to. And if I could invite you just to read that, and in particular what is said is about ignorance of the law. So that's internal pagination 479, 170 continuous pagination. The next point I wanted to draw attention to, having finished with that citation, is to do just briefly.
Well, you would say presumably that there's no basis for any rule that you are deemed to know the terms of your contract,
No.
bearing in mind that some contracts may be very simple and you'd find it very difficult to say that you didn't know what you'd agreed to, but other contracts may look more like a book.
Precisely. And it's not difficult to envisage a scenario where you have a complicated commercial contract with numerous provisions, where you don't even come close to the scenario of expecting an individual person to be fully on top of every single provision. You may have a debate as regards what the precise meaning of that is. And my own friend's position is that through no consideration you are stripped of a right. And in our respectful submission, that it's that submission which actually causes disturbance as to sort of standard and established principles of contract law, not the contrary. It comes come back to the question of certainty, which I think is probably his drumbeat, just briefly in a moment. So the second point I was wanting to just briefly take your lordships to again is it's in the same bundle. If we just briefly look at Blackstone, because I don't think we did, we've looked at Blackstone indirectly in terms of the passages referred to in Payment and Jani, but it's briefly worth just turning it up. And my Lord Justice Males has already looked at it, given the observations you made as regards what's said within it, but I think it's worth briefly just looking at it a little bit further.
Yep.
It's behind tab 11 in the same file I think you should have open. And so it's a 1973 case, which obviously postdates Evans and Young and Leafley, but none of those authorities are cited to the first instance judge, Mr. Justice Swanwick. And indeed, interestingly, he observes in the judgment that he starts his discussion at 1501, page 268, and the reference he seems to have been given by the parties is a judgment of Lord Applicant in United Australia, which talks about full knowledge at B as a sort of high authority. He then seems to have been referred to two first instance decisions, which didn't really help him particularly. And then he observes and makes his conclusions without the guidance of any direct authority. And so he doesn't appear to have had in mind or had cited to him Evans, Young and Leafley, which of course were the together with Kendall, the observations of Lord Blackburn and Kendall, the authority which was persuasive in Payment and Jani, or deemed by them to be in fact be binding on the point. The judge's obviously conclusions in that respect aren't, as has already been observed, consistent with the ratio in Payment and Jani, and would have to be recharacterised. It's not per se a decision which is wrong, because the observations made as a question of conclusion are pretty obvious in the landlord and tenant context. But the proposition of law at F obviously is in conflict with the higher authorities which are referred to. And we say that explains why then you see in Payment and Jani the rationalisation of this line of authority on the basis of a common sense proposition, not a rule of law. So that might be the most obvious explanation for why we see that proposition set out there. The further oddity actually of the case, well, there are two further oddities of the case, which are independent of those points. The first is that Matthews and Smallwood does seem to have been cited to the judge in argument, according to the head note, but not referred to in the judgment, curiously. And I've already taken your lordships to Matthews and Smallwood, and you can see in more recent Court of Appeal authority, Matthews and Smallwood was in fact referred to with approval, I think, higher level, and then being more recent authorities which often go back to Matthews and Smallwood in the landlord and tenant context. So it doesn't sit easily in our respectful submission with a judgment of Matthews and Smallwood, which talks about knowledge of breach. And indeed the further observations in the passage that I took your lordships to yesterday. The other case which caught our eye and cited in argument, Scarf and Jardine, and in Scarf and Jardine, of course, we have the statements of high principle of Lord Blackburn. If we just turn back to those, we're a little bit puzzled as to why this case has been identified by some of the Australian cases and or criticisms of Claimant and Jarni as being on their side of the fence, if I can put it that way. It's at page 60 of the continuous pagination. If we turn to Lord Blackburn's judgment, which starts at page 69 of the continuous pagination, but the passage which I think we've been homing in on is the one at the bottom of continuous pagination 75 or internal report 360. And if I invite your lordships to read that paragraph at the bottom and then over the page, we would respectfully suggest that what Lord Blackburn is saying there seems to be entirely consistent with what he said in Kendall. It's in particular the first few lines at the top of 361. Party in his own mind has thought he would choose one of two remedies. And really the qualifying statements are then to do with communicating it to the other side, which of course is there where we get the objective test. So that was the second point I wanted to just briefly identify. The third point is legal certainty, and just to go back to a point which I think was briefly alluded to by my Lord Justice Mayles yesterday in discussion with my learned friend as regards the observations and the heavy reliance by my learned friend on Lord Bingham in the Golden Victory, as has already been identified, dissent. And it may be just useful for us to briefly look at the majority reasoning in that respect and how legal certainty...
Well, yes, but it is a dissent which, although there is, in the majority, something you're about to show us saying, well, certainty is not the be-all and end-all, it does receive the approval of the Supreme Court in later cases, and there are other cases, including in our bundle, such as the scap trade, which do talk about certainty as a very important principle in commercial law.
Yes, so the way we would put it, and we respectfully endorse the observations of Lord Scott in that case in the majority, is that the way it's put is that it's an important theme, I can put it that way, an important objective, but not actually a legal principle as such. It's a desirable and we would respectfully refer your lordships to Lord Scott's judgment. It's probably in the second folder, Golden Victory. So it's page 383, paragraph 38, and it's the sideline passage, which it really lies at the heart of the difference between the majority and the minority. So I wouldn't balk with the proposition, considerations of certainty are important, but I think it's important to understand the context of that. And in the later cases, which I think your lordships referred to in the scap trade and also Muir shipping, I think is the other one that my learned friend referred to. As I said, when you actually look at the fact pattern of the context of what those discussions are, certainly in Muir Shipping, by Lord Hamlet's in the context of discussion about whether something is anchored in contract or not. Here, of course, the proposition we're dealing with is not a contractual principle at all. It's a general common law principle. And in that context, we would respectfully submit that there is no difficulty created in any of these cases by upholding the commonality of that principle across the different situations which arise. Now, the other point I just wanted to briefly draw out in relation to so-called difficulties in the context of an unscrupulous landlord, which I think was one of the matters preying on the mind of Justice Swanwick when he made his observations. It's important to understand, as I've already said in the landlord-tenant context, that the concept of a right of re-entry is not simply something which is contractual. It's an inherent property right which is associated with the land, and it's inherent in the concept that where you have the greater interest in the land, that you have the reversionary interest and right of re-entry as a matter of law, irrespective of what is in the contract. And of course, in the context of rights of re-entry, in the context of rent, the situation is perfectly obvious, and there will be no need for any factual inquiries regarding what a landlord may or may not know in that sense. And outside the context of rent, if we consider other breaches, of course, there's statutory provisions under Section 146 of the Law of Property Act, which provide for written notice, which restrict, as a matter of statute, the ability of landlords to re-enter without having complied with the statutory provisions. And that obviously is a 1925 Act, but it can be traced back to earlier acts. There's a Conveyancing Act of 1880-81, which was in similar terms. So it's not as if actually this particular area, as a matter of practice, should give rise to any particular concerns or difficulties. My lords, unless there's anything further in relation to those points, I was going to then move on to the next heading, which was dealing with obviously available knowledge and COSMA.
Yes.
On obviously available knowledge and COSMA, I think I can probably take the matters fairly briefly. Your lordships would have seen that my own friend's launch pad for this submission is in effect paragraph 74 of the judgment of Lord Justice Riggs, and it's worth just locating that discussion within the context of the wider case. So I think we're now in folder 2 for COSMA.
Yes.
And it's tab 33.
23.
Sorry, 23. Did I say 33? My apologies. If we just look at the order in which the discussion takes place, we can see that paragraphs 36 and 38 is where there's a discussion of the doctrine. So that's the bottom of continuous pagination 675, the sideline passage. And there's discussion about estoppel, which then follows. And then we have the actual ratio of the case at paragraph 69. So in effect, that this wasn't an election case at all on a proper analysis of the case, because in this case, dealing with the claim, so little d, dealing with the claim, is not necessarily inconsistent with repudiating liability for indemnifying the insured in respect of it. And then you see at paragraph 71, the judge then goes on to say, if I'm wrong about this, and then it goes on to the second issue debated on the question of were the communications or the effect of them an unequivocal communication. So that actually is not dealing with knowledge either. That's dealing with the second objective question of conduct. And then we see a discussion about paragraph 73 of Mr. Justice Mance in the ICCI and Royal Hotel case. And the passage which he refers to here is talking about the second issue, if I can put it that way, of conduct. But in fact, you will recall that it's in that judgment you see quite a lengthy discussion about blind eye knowledge, if I can put it that way. And then we have paragraph 74, and the discussion is talking about in relation to this, the analysis. So the analysis is back to the question of conduct. Obviously, objectively, it's an objective exercise. He then goes to say, I do not think that it is saying in the case of election, the party with a choice will be bound by sufficiently clear appearances, even in the absence of any informed choice. So you see the reinforcement of the concept of informed choice. And he goes on to say that's a potentially difficult subject. He then goes on and says, however, there will be some circumstances where even in the absence of an actual election, the party with a choice created by the relevant knowledge, and then the shorthand actual obviously available, will be regarded as having exercised it after reasonable time has passed. And the references there seem to be to the proposition of being treated as having exercised it after reasonable time has passed with the relevant knowledge, and that's what you get from the passages in the Kanchenjunga and Clough. And so we would respectfully endorse the reading of the judge at first instance, that in context, actual or obviously available would appear to be a reference to the blind eye knowledge line of authority, which was the subject of detailed discussion in Mr. Justice Mance's judgment. That seems to be how my learned friend pursued it at trial, in the sense that he used the phrase obviously available knowledge to signal his submissions that this was a case of Mr. Ensor deliberately not acquiring the relevant knowledge, and you get that from the passages and the references which you've already given you in the written argument. So unless there's anything further on that, I was then going to move on to just briefly deal with the grounds now, just as a summary. Mm-hmm. So the first ground 1A, is this all new? Is this the first question? And in our respectful submission, the idea that the proposition that my learned friend now seeks to pursue, that there must be some deemed knowledge in express terms contract cases, is not one which is pleaded or advanced in the court below. The pleading in the court below, I'm sure your lordships have already looked at it, but the reference for it is in core bundle 15241 is was or and then in brackets or ought to have been close brackets aware. On any reading, that's an assertion of actual or constructive knowledge. There is no pleading of taken to know or deemed to know. The assertion which follows that, as regards this being a term in the contract, was simply further particularisation of the
sorry, which page were you on?
Sorry, should we go to
15?
May assist your lordships to turn it up. So it's core bundle 241, I think is where
241.
it's found. It's not. It's not. It's one of those pleas where you have to scroll back a few pages to get the paragraph number. It's paragraph 15, 9b, and so it's at all material times. URE was, and there are brackets, or ought to have been aware of its right. And then there's a list of criteria. This is because it was an express clause in the contract. So that's a particular in support of the higher proposition. There was no submission by my learned friend in the court below. We don't need to explore this 3 days of cross-examination of Mr. Ensel, everyone, because actually there's a very short, simple point on this. That point wasn't made in opening or in closing. It was an evidential point relied on by my learned friend in support of URE did know it, which of course was a triable issue, or he ought to have known it. And there was some confusion on our side as to exactly what he meant by ought to have been, but on any view, it's a constructive. It appears to be some sort of constructive knowledge test, not a deeming or a taking to know. And if we'd appreciated that this was a live point, then of course we would have sought to have flushed it out and had it addressed at a much earlier stage, and then there would have been subsequent consequences for the reasons I've already indicated. I'm not sure if I need to take you through every single twist and turn of all the different references in the written cases. You've got those, and you can see that the passage and the way the matter was presented in fairly clear terms from those. Perhaps most clearly is the judgment itself. Paragraph 92. There was no material dispute between the parties as to the applicable principles. Well, there wasn't. That's the reality. There wasn't really any dispute between us that the key issues at trial were: did Mr. Ensel know, or was there some sort of deliberate blind eye knowledge? That was the trial before the judge. She dealt with it, and we would respectfully submit it doesn't lie in the mouth of my own friend now to criticise the judge for something that wasn't raised. Well, as in relation to this, you've already got, I think, the submission by me by reference to prudential assurance. I don't know if we should turn that up or not, but it's a judgment of Lord Justice Lewison. It's in Authorities Bundle. It's the second folder behind tab 28, and it's worth just briefly looking at it. I suspect
Tab 28 seems to be Mr. Justice Mann.
Sorry. Shall I give you the page references, maybe, where there's
Yes.
a glitch between hard copies? So 850. I think that there may be, my apologies, there looks like there might be slight divergence occasionally between the electronic and hard copy. So 850 you should hopefully have prudential assurance. It may be tab 27 in your bundle then.
Oh. I don't have anything between page 849 and 890.
It's missing.
Ah. Our apologies. That may explain why the pagination, the tabbing's gone wrong.
Yes.
Well, can I ask someone behind me perhaps just to see if we can deal with that by way of printout? Yeah. Do you know why? Do you have an unmarked copy? Which one? It's volume 2.
Why don't you see if you can get 3 copies?
Should we see if we
for
can get
us,
3 copies?
and then come back?
Our apologies. Shall I? It's probably not best, but just so that I don't take a lot of time, we'll get you 3 copies. But if I just read out the relevant paragraphs, paragraph 25, please.
That's all right.
if the point is a pure point of law, and especially where the point of law goes to the jurisdiction of the court, an appeal court may permit it to be taken for the first time on appeal. Where the point, if successful, would require further findings of fact to be made, it is a very rare case indeed in which an appeal court would permit the point to be taken. In addition, before an appeal court permits a new point to be taken, it will require a cogent explanation of the omission to take the point below. So, in our respectful submission, that's an endorsement of and indeed there's reference to an earlier case called Crane in paragraph 26 below it, to the point that you can't simply turn up to the court and say this is a point of law. You don't need to ask for an explanation as to why that has arisen.
Why isn't it potentially a cogent explanation if it is a pure point of law that we didn't think of putting the case that way before?
Well, in our respectful submission, there would then be a potential analysis of whether or not there was a good reason or not for that. In some cases, there may not be. There may be a good reason why it wasn't. In other cases, there may not be. Hence, why there's a need for an explanation for it to be cogent. So in our respectful submission, often people just look at Singh and Das and they say, well, let's just ask ourselves if it's a point of law, or if it is, well, there's no point opposing it. But on our submission, actually the authorities go further than that, and this is an example of that, that in the context of a new point, the court will require an explanation, a cogent explanation, and on points of law, that may well be an explanation which satisfies the court, and it's satisfied it can deal with any prejudice thereby without the need for further consideration. But it's an additional consideration is our point. So in effect, we have three submissions we would seek to make under this heading. The first is the course of the litigation would have been very different. And it's a point that I've already made, I think, briefly yesterday, that this was a case where actually there may have been an additional line we would have wanted to pursue based on vitiation of any, in this context, deemed knowledge. In a similar way that was ventilated and explored in TCG, wasn't explored in the court the court below, just for a discussion as to why that might have been a fertile ground for us to explore. See paragraphs 120 and 121 of the judgment below. Secondly, sorry, do you want me to briefly take you to it?
Well,
It's at core behind tab 11, page 174. So that's our submission on factual inquiry. There's a wider point to do with the difficulty in this case as regards the course of litigation in the court below, to do with, even if we put to one side that factual inquiry point, to do with, well, we would presumably then have sought summary judgment. We would then have been in a position to know whether or not at that stage this was a valid point or not, and decide whether or not, if it was adverse to us, that we would carry on with what was always our secondary claim rather than our primary claim. And the position of the company, obviously, in relation to ATE, which was a necessary requirement which we needed to obtain. The because they applied for security for costs, and we had to increase our security for cost cover, and there were judgments handed down at first instance in that respect. So the short point is that even if this is just viewed as a point of law, it has consequences which obviously go to the question of cost, but on our side go beyond the question of cost. It's not easy to see how those would be unravelled, particularly in circumstances where we have statutory provisions which, on the face of it, provide that ATE is not recoverable. So that's our second point. Our third point is that in relation to the question of explanation, which I've already alluded to. So that's the precursor point, if you like. So we say, first, the judge didn't err in failing to find that URE should be taken to know the express terms of the contract because she wasn't invited to do so. Sorry, she wasn't invited to do so. Secondly, we submit there is no doctrine or rule of law that parties taken to know of their express contractual rights, and I've taken lordships through the authorities in that respect. Third, insofar as NHG's submission is not that there is a different legal test, but there is a presumption that URE was aware of its express contractual rights, that presumption was comprehensively rebutted by the evidence adduced in the learned judge's findings as to URE's state of knowledge. Next point, the evidential presumption they did plead was because we were in receipt of legal advice, and that, of course, is a burdensome presumption, which was rebutted by us laying bare the full extent of all legal advice provided. The full files were disclosed. And we had the trial we did with the express finding we did at the end of it, that Mr. Ensor believed that the clause only applied to insolvency events. As it happens, precisely the same submission and the defence that the defence were running for many years. Ground 1B, this is, I think, the semantic point that in some way we should be drawing a distinction between knowledge and understanding. And we would respectfully suggest that the judge was quite right to identify that simply knowing the existence of a clause doesn't assist in knowing whether you understand it gives rise to a right. I think in one of the textbooks, the phrase is used, the penny must drop. You may be interested to see, and I make apologies to my own friend in advance if this is viewed as a somewhat below the belt point, but in his own submission...
You're going to make it anyway.
I'm going to make it anyway, but just giving advance warning, I'm throwing something back at him. He said to the trial judge in his closing submissions, if we look at core...
Supplementary, I imagine.
Sorry, no, so it starts off in the core, if we may, just it's probably quicker that way.
Okay.
Tab 7. So within my learned friend's own skeleton, it's page 90 is the reference I have for it. It's in paragraph 41. This is the passage where my learned friend says this is what they set out at trial, and it's within subparagraph 3 where he quotes from his own written closing. It's the sentence, did not know or understand. He's using the phrases interchangeably there, as you'd expect. If you want further references, in the supplemental bundle, in oral closings, the same phraseology was used I'll maybe just give you the reference. This is supplemental bundle, tab 29. Sorry, not tab 29. Tab 34, page 321. It's pages 51 to 52.
It's just the same point, is
The
it?
same point.
I'm not sure it gets better if Mr. Riley said it twice rather than once.
I will take the judicial indication and move on. So ground 1C, then, obviously available knowledge. In this context, I think I probably need not do more than just repeat the summary of the submissions I've made as a matter of law as regards what the law provides and what.
But you say that means blind eye knowledge, and the judge made a finding on that which is in your favour.
Yes. So now if I can turn to ground 2 and our additional response notice grounds. Our brief submission on ground 2 is that really there is no proper ground 2 here. Really, Marlene Friend's submissions are in support of her earlier finding, which we seek to challenge by our response notice points, that she wasn't merely making a finding of delay, she was making a finding of positive conduct. And with respect, we would submit it's a misreading of the judgment to suggest that the judge is doing anything other than in the passage that is attacked on ground 2, then dealing with the positive conduct in her judgment in the earlier paragraphs, and then when she gets to the question of just mere delay, dealing with that as a separate topic, and that's a fair reading of her judgment. That's what she's doing. Logically, you might, I suppose, have started with just mere delay first and said, well, that's not enough. But I asked myself the question, is there positive conduct? That's really just not a point of substance in my respectful submission. So the real question, actually on this point, is raised by our response notice, which is, firstly, under ground 1, what does the express wording provide for in this contract? Do we actually have the fork in the road concept, the election concept? Is it actually properly truly engaged, and or bearing in mind that the clause, can the other side say that any conduct was an unequivocal communication of that election? And then there's the second ground, which is was the judge right to find that there was positive conduct amounting to an election? On the first point, then, just dealing with that briefly, the relevant provisions of the contract are in the core bundle behind tab 11 of page 127. Sorry. They're not. It's behind tab 18, page 317. And under the heading termination, it's in the chapeau in 10.2, the starts that the supplier may terminate this contract at any time for all or any supply premises if, and then we have then the trigger clauses which follow. You'll note that in 10.3, the mirror provision for the customer provides the customer may terminate this contract, and then it simply has the mirror provisions. Also note within 10.2b that in a material breach circumstance there's a 10-day period whereas in the provision dealing with the customer termination context at 10.3a, there's a 20-day notice period. And also note the provisions dealing with termination payment in clause 10.4 and 10.5 are reserved only to the supplier. Now, the learned judge's treatment of this topic starts really, I think it's at page 180 in the core bundle is where the start of it is. And I should say, this point was raised obviously before Mr. Justice Mulder, and she wasn't willing to grant a summary judgment on this point. It was raised before this judge as well, and this is the reasoning she gave for disposal of it. In paragraph 134, the learned judge takes the words at any time in clause 10.2 and concludes they are inherently ambiguous. And then she postulates at least 3 meanings for it. And we would respectfully disagree with the judge as regards her analysis of those different rival constructions as she was considering them. The first point...
Sorry to interrupt, but do we have, by the way, Mrs. Justice Mulder's judgment?
You do, yes. Let me just get you the reference for it. It's supplemental tab 23.
Oh, yes. Yes, thank you.
I wasn't proposing to take your lordship's passages in that, but I think...
No, as long as we've got it, that's fine.
Yes, you have it, and that I think deals with the rejection of our summary judgment application on this point, and also the findings in relation to estoppel. So back to paragraph 134 then, and the words at any time. Our first submission is that we respectfully disagree with the proposition that only the first 2 interpretations and the natural meaning of the words. We would respectfully submit that the first part of clause 10.2 is plainly dealing with when the right may be exercised. It's not dealing with the trigger event giving rise to that right. And that is what's provided for by the relevant subparagraphs. It is obvious that the right must arise in the occurrence of the events in the subparagraphs. So logically, reference to any time must be dealing with when the right can be exercised. And we would submit the judge's first interpretation conflates the different parts of the clause which serve different purposes. And secondly, render the words at any time superfluous. Secondly, as to her second possibility, we would respectfully submit that this is in fact a rewriting of the clause. The phrase may terminate at any time most naturally means exercise of the rights to give notice terminating the contract. The judge's second possibility effectively means may serve notice immediately effective at any time, which is very different to the words used. We would respectfully submit that clause 10.4 and the linkage to that is simply dealing with the common sense proposition that the date for termination must be identified in the notice, and doesn't, in our respectful submission, support the conclusion that at any time it is as the judge rationalised it. Our third point is the judge failed to consider the difference in wording between clauses 10.2 and 10.3. And whilst we accept that the arguments based on surplusage have their limits, there appears at face value, and you can see on the clause and approximate clauses, a deliberate attempt to give the supplier more generous termination rights. That's manifested in not simply the difference between the wording at any time in clause 10.2 and 10.3, but also the longer periods for remedying material breaches, and of course the termination payment provisions. This is not a question of drafting overkill, if I can put it that way, which is sometimes a reason to diminish the force of differences in wording.
Can I just ask you about that? If you look at 10.2 and 10.3, you've pointed out the absence of those words in 10.3. 10.2, however, has some additional words which are for all or any supply premises, because the supplier can terminate for one supply premises, two supply premises, or all supply premises. And those words at any time could be, it seems to me, regarded as connected with that point, so that it could be said that the fact, for example, that the supplier had decided to terminate for premises A, B and C on day one wouldn't stop it, on one view, from then later coming back and saying, I'm now going to terminate for premises D, E and F, subject to questions of waiver, obviously.
Well,
so there's a material difference between the positions of the parties, which might be said to be reflected in the wording of the clauses.
No, that's an interesting observation. It's of course not the reasoning of the judge at the first instance, but secondly, we would respectfully submit that supports our conclusion that what is recognised in this contract is that whilst we can have a debate as whether or not this excludes the doctrine or not, that may be a semantic debate. The reality is does the proper meaning of this contractual clause as a matter of practice effectively mean that the doctrine can't bite? So when I say exclude the doctrine, I don't obviously mean in the sense of wording in the contract which says for all purposes and hereafter the doctrine of election is excluded. That's not the point I'm getting at. The point I'm getting at is that where you have an express acknowledgement that you have a right which can be exercisable at any time, you're not contemplating that there is a fork in the road for the person who's required to exercise the right. And secondly, the counterparty objectively can't assume simply because they're carrying on that they must be forfeiting that right. And those are the two propositions you see in the BDW case. And even if you were to say, well, part of the rationale for this is to deal with the fact that you may have other supply premises, in our respectful submission, that tends to illustrate the point in our favour, which is that at any time is a concept which can apply for all or any supply premises. So I think the short point is that even if you were to read it as in some way linked to the concept that there is more than one supply premises, that doesn't defeat our primary proposition. It's at best neutral in that context.
Would you accept that if there is conduct which does amount to an election to a firm with the relevant knowledge, that the right thereafter to terminate is lost, notwithstanding the words at any time?
Well, the difficulty is, I think, in conceptually analysing that is when you get to the question of unequivocal communication, because without an express acknowledgement by the person who is on the face of it conducting himself in a way which might otherwise be interpreted as an unequivocal communication, because of the presence in the clause of at any time, necessarily that in our respectful submission means that you can't conclude that the conduct is unambiguous as a matter of contractual context. So the short answer is that in our respectful submission, as soon as you have those words at any time, it would probably require something stronger than simply continuing to perform the contract for there to be the doctrine to come into play. But it is possible the doctrine might come into play if there were something stronger and more unequivocal. Does that answer the point?
Yes, I think so. Thank you.
It may not have hit home as a matter of acceptance, but I think the submission really is that in the context of analysis of election, the starting point is what is the meaning of the clause, and what does that then objectively mean when you come to the question of conduct. And in our respectful submission, a finding simply you're carrying on with the contract, when coupled with these words, you can at any time, for all or any of the supply premises, trigger, if certain events arise, you may terminate. In our respectful submission, that points towards the conclusion that simply carrying on with the contract can't of itself be viewed as being an unequivocal communication of a decision to elect. And we would respectfully submit that, in fact, what seems to be going on here is by way of a side wind, even though Maloney's friend doesn't plead out and prove an implied term, really that's what's going on here. He's seeking to, without pleading and satisfying the requirements of an implied term, get a restriction on the contract. And that there is no, subject obviously to our points as regards the construction. If you're with the judge on the question of construction, then these points don't bite to the same degree. So just one further point on the commercial factors. We would respectfully submit that there is a good commercial reason here why there are differences between the two different positions. Indeed, the point about supply premises is a further one. And the commercial recognition that if URE had sought advice, had been cognizant of this being an issue and a commercial issue as to why it would want to nurse its rights, is recognised by the judge in a different context, in paragraph 144 of her judgment, in the context of probably an unnecessary exercise on the judge, where she postulates what might have happened if URE had sought advice and what a lawyer might have done in that scenario, which probably would have said, well, you may want to consider reserving your rights. We obviously then get into the SK shipping issues as regards whether or not that would be effective or not. And our understanding is, in the context of the SK shipping case, Ms. Jessica Foxton says, well, there's no sort of absolute here. The exercise is informed by the contract, but not dictated by it entirely. I think that was in effect upheld by the Court of Appeal. So we would respectfully submit that there is good commercial reason, both for the difference in drafting, but also why a supplier who's supplying electricity would want to have that ability preserved, particularly in circumstances where, on the facts of this case, and Malone Fred, Mr. Wigley will come on to make submissions on in due course in clause 10.5. The fifth point, the judge, we respectfully submit, is different from the judge in paragraph 1345, where she says the position is not dissimilar from election to terminate or affirm following a repudiatory breach. We would, obviously, if you're with us on the primary submissions as regards the interpretation of clause 10.2, then we would submit that is wrong. That in essence, we should be viewed, as I've said, at the BDW end of the spectrum, not the start fork in the road type situation where there's a repudiatory breach. Clause 10.2 deals with a number of different provisions which probably on their own wouldn't be repudiatory. So the material breach provisions obviously have an additional layer of requirement in relation to the consent of notice in relation to remediable breaches or other non-breach situations. So on the face of it, what they're dealing with is a scenario which is not just simply equivalent to a repudiatory breach context. So that's a quick canter through our submissions in relation to respondent's notice point 1. Unless there's anything further your lordships wanted me to address you on in that respect, hopefully that set out the main points for you. It's ultimately a question of mainly interpretation of the contract and whether or not we gain any traction in relation to the submission about the proper interpretation of it.
Yes.
The next question then is our ground 2, and I think probably for these purposes we need to look back at what the judge said and the reasons she gave for her conclusions on this point. So we can go to core page 182, please. So you see there's some discussion about clause 13.1, which starts in paragraph 136 of the judgment. And we then see at 137 an acceptance of my submission that in the context of a supply of electricity contract scenario, there is some force in the idea that carrying on a continuation of the contract itself may not be particularly significant. Your lordships will appreciate that in this contract there's a slightly unusual situation that even after termination of the contract there's a deemed contract provision by statute in relation to the supply of electricity. So that's another unusual feature of this case, which you see in the contract provisions where there's reference to the deemed contract rates. And then she goes on to say, accepting there's some force in that submission, however, continuing to supply electricity because there's no possibility of doing anything else is one thing. Positively requiring NHG to perform its obligations is another. And then she refers to the specific acts she then lists out are cooperation in relation to the AMR rollout and continuing to negotiate for the long-term contract. As to the question of negotiation for long-term contract, that is not seeking to require the other side to perform a contract or anything to do with its contract. It's, in our respect for submission, an entirely neutral point vis-à-vis affirmation when you're negotiating a long-term contract. The second point raised by the judge, found by the judge in support of her reasoning, was the AMR rollout.
I mean, it wouldn't make much sense, would it, to terminate this contract and continue negotiating for the long-term contract? Why would anybody do that?
Well, one can see in the context of this case that clearly where the judge has already found that this is a placeholder, that you're continuing to negotiate the long-term contract. But when viewed from the prism of, is this sufficiently equivocal conduct for the purposes of treating us as having clearly communicated a choice, in our respectful submission, simply because you are not immediately exercising your right to terminate, cannot of itself be viewed as giving up the right, if I can put it that way, to terminate. So simply because you are continuing to negotiate the long-term contract doesn't of itself give the clear and unequivocal signal. But I take your Lordship's point that if you link it to the question of why the long-term contract is in place, you might seek to draw the inference from that that's supportive of the notion that you are wanting to keep the initial contract alive in order to continue to pursue those negotiations.
I mean, particularly given that the termination right arises on an amalgamation, because the long-term contract which you are negotiated will inevitably be with the amalgamated entity. So doesn't continuing those negotiations suggest that you're quite happy with the amalgamation? Because if you were bothered by it, you stop negotiating.
Well, I can see that point. I think I go back to the primary submission, that the question still lies as to whether or not ultimately that is sufficiently unequivocal conduct. And it may well be that your Lordships conclude that what the judge has found here is enough. If you're against me on ground one, I can see that. It may well be that your Lordships say I'm unfairly identifying only the events that the judge has cited. But we would respectfully submit that negotiating the long-term contract of itself isn't sufficiently positive conduct to amount to waiver. And on the AMR contract, AMR rollout, the primary reason why, of course, we're doing that is for our regulatory requirements in relation to AMR rollout. And as the judge found, the AMR rollout wasn't a requirement per se under this contract. You see that from her judgment in paragraph 23. But I take on board the point that if your Lordships take the view that I'm unfairly, in effect, ignoring some of the wider picture that's encapsulated by the judge's findings, so that may be an alternative way of reading the judgment. But the judgment as it stands simply refers to negotiating to the long-term contract. Yes. and the AMR rollout. And those two factors we would submit are not sufficiently equivocal. But probably the more important submission on the additional grounds is the significance of the meaning of the contract, and our respectful submission that probably is likely to guide the debate thereafter.
Okay, thank you.
I think probably I should now hand over to my old friend Libby to give an opportunity to address the court on clause 10.5, unless there's anything further I can assist you with.
No, very good. Mr. Wibley.
Thank you, my Lord. I'll try and address you from here rather than spend time trying to reorganise with Mr. Sims. We will submit that the arguments being run on ground 3 are effectively a repeat of the arguments that were made before the judge. And in large part, we say that she was correct for the reasons she gave. So I want to focus my submissions, if I can, on the way in which matters were put to the judge and the evidential material before the judge, and in particular the factual findings that the judge made, which underpinned her interpretation of clause 10.5. Before I do that, though, can I start with clause 10.5 itself, which is behind tab 18 in the core bundle at page 318. It is easy when we are having this debate just to look at one or two words within the clause, but I'd like to have a look at the clause as a whole, because that sets the immediate context. So where in relation to any supply premises the contract is terminated by the supplier pursuant to clause 10.2. So I believe this observation has already been made by Lord Justice Miles. This could be a termination in relation to all supply premises, one supply premises, several supply premises. The customer shall, within 10 days of the termination date, pay to the supplier. So it's not simply that there is a calculation to be carried out. Actually, there is a calculation to be carried out and a payment to be made within a short period. 50% of the remaining value of this contract to the supplier in respect of the relevant supply premises, and then in parentheses, as determined by the supplier acting reasonably, as notified by the supplier. So we're not simply concerned with the interpretation of the term remaining value. It is how that term is deemed to work or should work in the context of a calculation to be carried out in a short period in relation to one or a number of supply premises. I'll come to the competing arguments in a second, but we would submit as a starting point, when one reads the term remaining value, it is akin to the balance of the contract price. That is what is being talked about in this context. And that in some ways, that instinctive initial reading is all one needs to do. In terms of the factual context then, if we turn to the judgment behind tab 11, can I ask your lordships to turn first to paragraph 9, which is at page 129 of the core bundle. And I start with paragraph 9 simply to reinforce the point that the background section in the judgment is not a rehearsal of the evidence but constitutes findings of fact made by the judge. So all of the matters at paragraph 9 onwards, as found by the judge, are relevant to the interpretation of the clause. The next paragraph then I wanted to go to is paragraph 12. And if I could ask your lordships just to read paragraph 12 to yourselves, that sets out, we said, key findings, or some of the key findings in relation to the purpose behind this individual contract. Could I then ask you to turn to paragraph 19 on page 133, just to identify the key finding in the middle of the paragraph, that it was agreed that this contract would be a placeholder to be superseded by the long-term contract in due course. And then I'd like to go on, if I can, please, to paragraphs 38 and 39, which begin, I believe, at page 142. Now, before I look at paragraphs 38 and 39 themselves, there was a debate yesterday with Mr. Riley about the intention, or lack of intention, he said, to purchase energy in advance. He made submissions on the basis that there was no intention that any energy would be purchased in advance. That's not quite right. The judge says in her judgment there was no intention to purchase significant quantities of energy in advance, which is an important clarification. And in fact, what one sees from paragraphs 38 and 39 is that the position is when this contract is entered into, URE lacks funds, therefore there is an agreement that advance payments will be made to allow URE to purchase energy in advance, but that is only ever intended to be a temporary arrangement. It is envisaged by the parties that funding will be obtained by URE. It is of course also intended and envisaged that the long-term contract will be entered into, but it is envisaged that funding will be obtained and the advanced payments will be moved away from. There was a factual dispute between the parties as to the nature of that agreement and whether it was an agreement simply for a fixed term of 1 year, which was NHG's position, or for a longer period until funding of the long-term contract being URE's position. But on either party's case, or on both parties' case, it was accepted and it was common ground that that was not to be a permanent arrangement. It was envisaged that there would be forward purchasing in due course. If I can then turn to the relevant passages in the judgment where the judge addresses this issue, they begin at paragraph 181, which is on page 200 of the bundle.
Sorry, there doesn't seem to be anything in those passages you've just shown us about forward purchasing, unless I've missed something.
I apologise. That may be because that is elsewhere within the judgment. I took it as common ground from what Mr. Riley said yesterday, that the purpose for the advance payments being made in the short term is that advance payments are being made to put URE in funds to allow URE to purchase energy.
Right, but that doesn't seem to have to do with forward purchasing of energy in the sense of going out and buying into the future. It might just have been, it just seems to be a cash flow point.
Well, it was a cash flow point. Apologies. The point I was trying to make was that yesterday it was suggested that there was no intention to forward purchase, and there was no forward purchasing at the outset. And Mr. Riley addressed you on the agreement that was made at the beginning for advance payments, and he relied upon that agreement as being part of the relevant factual background, showing that there was no intention generally for advanced energy purchasing. I'm simply trying to make the riposte of that, which is, well, yes, there was an agreement at the outset for advance payments, but that was intended to be a temporary arrangement. It's an arrangement for cash flow purposes, but because it was only a temporary arrangement, understood to be a temporary arrangement, it does not follow from that temporary arrangement that there was never any intention to forward purchase energy in years 2, 3, 4 under the contract.
But are you confusing forward purchase with just advance payment for the next 3 months, which is what this is envisaging, I think. A rolling 3-month payment in advance, not forward purchasing for years 2, 3, and 4. Or whatever.
Well, but the difficulty was that there was insufficient funds to purchase for years 2, 3, and 4 at the outset. They raised money by way of advance purchases, so energy was being purchased quarterly, if I can put it that way, and that's why in the judgment the judge refers to not no energy being purchased in advance, but only effectively small quantities being purchased in advance. But it was only ever envisaged that that would be a temporary situation, and that situation would be moved away from in due course when funding was available. And when funding is available for URE, URE is then in a position to do the advanced purchasing properly, so-called, so not just payment in advance, but buying years' worth of energy up front.
That seems to be, I'm sorry, that seems to be, what, just judging from what's said in 39, it seems that that was expected to happen when the long-term contract was entered into. Because that seems to be, 39, the judge says Mr. Ennis's understanding was that the advance billing arrangement was to last until the long-term contract.
Yes, that was Mr. Ennis's understanding. The understanding on NHG's side, as I said, was slightly different. They say it was an agreement for a fixed period.
I know, but this is the more favourable view from your client's point of view.
Yes.
But I thought under the long-term contract there wasn't going to be any purchasing of electricity because URE would be generating its own solar energy. Is that wrong?
There would. One assumes there would have been the purchasing of some electricity. The proposal for the solar farm means that during the daytime at least, a significant proportion can be provided. The judgment proceeds on the basis there would have been some forward purchasing, because that's one of the matters for which finance is needed. Perhaps if I move on from this point, I was only coming here to respond to Mr. Riley's suggestion that there was no intention for forward purchasing energy as evidenced by the agreement at the outset, just to identify that the agreement at the outset was not an agreement that was intended to be permanent. It was an agreement that was only intended to be in place for a short period of time. So it is not a definitive answer as to what the parties were expecting under this contract. In terms of the judgment then, beginning at paragraph 180, on page 200, so paragraph 181, the judge identifies the clause of paragraph 181 and then moves on at paragraph 182 to identify the submissions advanced by the parties. And if I can just highlight, it's the final subparagraph, it's Roman 9, which begins on page 201 over to page 202, is where the submission was made by URE that it had incurred significant startup costs and therefore known by both parties that it was unlikely to be making any profits. And I believe yesterday the question was asked, well, where did the judge's finding that this contract wasn't going to be a profitable contract come from? Well, that was the proposition expressly advanced through URE's arguments, and there was no demur from that, as you can see at paragraph 183. There was no submission or suggestion from NHG that this was intended to be a profit-making contract. And indeed, it was suggested yesterday that there was a loss of profits claim below, but that is simply not right. There was no claim for lost profits. What URE said is, as a result of the termination, it suffered a greater loss than it would have done otherwise. But it was never asserting that it would have made a profit had this contract been performed. And if I can take your lordships to the relevant passages in the pleadings, so the amended particulars are behind tab 14, which begins at page 210. It's page 221 of the bundle, which contains the remedies section of the amended particulars. And it's the amendment, paragraph 56, cap A. So URE simply asserted it was entitled to claim its losses, and they were not described as profits, and we'll come to the schedule of loss in a second. But while we're here, can I also ask your lordships to look at paragraph 57 and just note that the termination payment sought at paragraph 57 is £3.9 million. We then come to the schedule of loss, which is also behind tab 14, page 224. And one can see two boxes on the page. You have the middle box, claims contractual position but for termination, so that's the counterfactual. And the counterfactual was predicting a loss of £2,161, and the actual position was a loss of 3.7 million. So I appreciate it's not a question of hindsight when one is looking at the termination payment, but there is actually a close correspondence between the contractual termination payment and the actual loss, but it was not asserted that there would have been a profit on the counterfactual. The one other point that may be relevant is if one goes just over the page to
I was just trying to understand this schedule. You've got the second box, the left-hand side is actual, and that shows the income and the outgoings as a £500,000 loss. Yep, or short.
yes.
The right-hand side has income and then cost of sales. Well, aren't those cost of sales which you would have been relieved of?
Not on. So this is the counterfactual. That is what the cost of sales would have been had the contract not been terminated.
Yes.
So in terms of the actual position, That is in the bottom box, and it is the bottom box that sets out the costs that we say not relieved of, which are cost of sales of 1.9 million and administrative costs of 1.5 million. So had the contract been performed, we would have incurred total forward costs of just over £8 million. As it was, most of those were avoided, but there were still costs in the region of £3.5 million.
Where are those on the left-hand side?
So they are shown bottom box, the second column. So the first column is the point up to termination, and then the second column is the projected position, or is rather the position from termination up to the end of the contract.
Those are the costs that would be avoided, that were avoided.
No, the cost that were avoided is the difference between those two figures. So they are the costs that were not avoided. So the cost that were avoided is the roughly £8 million combined figure shown in the second box, less the sum of the cost of sales and the administrative costs shown in the third box.
Okay, so the third box is actually incurred expenditure, is it?
Yes.
I see. It's slightly confusing because the date is 14th November onwards, which is after termination.
Yeah, yes. Well, 14th of November is the termination date.
Yes.
So the way in which the calculation's been done is the first column is the net position up to the termination date, and then the second column is termination date up to the end of the contract.
But that's projected then, not actual.
No, it's actual because there are, for example, one of the criticised heads of loss is the Utilisoft contract that was not in fact terminated, under which liabilities continued to accrue over the course of the contract, because it was not a rolling contract, it was a contract that covered the entirety of this
actual
contract period.
costs. Actual
Yes.
costs of 1.9 million for cost of sales and actual administrative costs, are they?
Yes.
I see.
Can I turn next, please, to the re-amended defence, just to see how the defendant responded to this? And this is partly to address another point made yesterday. Page 257 is where the defence responds to the remedies claimed. And one can see on the following page, page 257, the response that is advanced. But what was not put forward below was any suggestion that there had been an anticipated profit and that had been calculated in the wrong way. What was seemingly accepted is the projection, and one can see this from paragraph 4b, that there had been, or there was expected to be a loss overall. Now, that pleading was made in the context, or that response is in the context of the alternative loss claim, but our understanding of the position below is that effectively a fallback or gotcha argument was being run by NHG, which is to say, well, even if you get home on your primary claim, because you were not predicting a profit, on our interpretation of clause 10.5, you don't recover anything. It was not suggested at any point below that there was some alternative calculation that we should have carried out that would have shown a different profit figure. So it was being put as a binary, it was put as a binary choice to the judge. And so the suggestions that were made yesterday that if your lordships were to find the defendant on this point, there would be a matter to be remitted to the first instance tribunal, that is an entirely new point. And we infer the reason that point is being made now is because of the fundamental unattractiveness of the argument being advanced, which is on NHG's interpretation, this clause is devoid of any practical application because the contract's not intended to be a profit-making contract. If I can return to the judgment then, starting on page 203. And it's paragraph 184 where the judge begins by looking at the natural and ordinary meaning of the language. She then addresses some of the construction arguments that are put forward in terms of, well, why wasn't a different term used? She deals with the point on charges, and in my submission, she deals with that point entirely correctly. She then makes the finding, we say, quote, furthermore, in circumstances where it could not be predicted in advance whether or when profits would be made over the duration of the contract, the value of this contract more naturally reads the amount payable under the contract. As I say, our submission is that that is a finding by the judge, and it is not open to NHG to seek to challenge that now. It is also a logical finding for the judge to make in circumstances where, and this was one of the variables underpinning the schedule of loss, where one has a contract that provides for a fixed payment price by the customer, whether that contract is ultimately profitable or not will depend upon the wholesale electricity cost over the course of the contract. That is not simply a variable, that is an unknown. It is requiring the supplier to look into a crystal ball. If one contracts that with the question that we say needs to be calculated, which is a matter of predicting future consumption, which I accept requires a degree of estimation, albeit past consumption is a far more accurate guide there, that is a far more obvious, far more commercially sensible thing for the parties to have agreed to. And then returning to paragraph 185 of the judgment, we see the judge saying that the calculation, in fact making exactly that point in relation to calculating usage. We then have the judge's findings in relation to the purchase of energy. As I've already said, it wasn't her finding that there was no intention to be no purchase of energy forwards at all. It was simply that there were not to be large quantities of energy purchased. We then see the finding by the judge, first of all, of 50% as a reasonable figure, and the basis of that for a reasonable figure was her acceptance that there would have been other losses or other costs. And then she goes on to make the final point, which I believe was made yesterday, which is that it would be counterintuitive to require a full loss profits calculation and then for one to only get 50% of that. The answer proffered by Mr. Riley yesterday was, well, there would need to be some account for advance payment, but of course we're talking about a 4-year contract, not a significantly long-term contract. We're talking about an interest rate environment where the Bank of England base rate in October 2017 was 0.25%. A 50% reduction in recovery for at most a 4-year acceleration, on average a 2-year acceleration payment, does not stand the test of scrutiny, we would say. Bearing in mind the time, if I can wrap up then just by making these points, that ultimately the matters underpinning the judgment at paragraph 185 are findings of fact that the judge was entitled to make on the evidence. And what the defendant is trying to do now is to say, well, because we retrospectively, with the benefit of hindsight, criticised your losses claim, somehow the judge was unable to find that there would have been or could have been other costs in setting up the business. We say that is the wrong approach, that it is settled law that when one is looking to assess the reasonableness of the clause, that is an assessment to be carried out as at the date the clause was entered into, and you have the clear finding by the judge, as already taken to at paragraph 12, of significant setup costs for the business. And that brings me to the very final point, which is, well, to what extent can the judge look at wider matters? And it seems to be the criticism run by NHG, well, because this could be a liquidated damages clause, you could only interpret this clause on the basis that it's allowing losses under the contract. But of course, that is wrong. Even where this clause is acting as a liquidated damages clause, the law is now clear, following the Supreme Court's decision with Desi, that liquidated damages clauses are not limited to simple pre-estimates of loss. The question is whether or not there is a proportionate interest, and the sum payable under the clause is disproportionate vis the legitimate interests of the party in ensuring performance of that clause. The case of Permavent has been handed up. I won't take your lordships to it now, bearing in mind the time, but that includes a review of the law by Mr. Justice Zacaroli, as he was then in Madesi, and an acceptance of the principle that one is able to look at broader commercial interest when assessing that. And if I can just give your lordships the paragraph reference to that, that is at paragraph 41, albeit it's paragraphs 33 to 44 that contain the summary of Madesi. And we say that actually the way in which the law has moved in relation to termination, to liquidated damages clauses, supports rather than undermines our position, because fundamentally the purpose of clause 10.5 is to cover URE's costs in the event there is a breakdown in the relationship. And we say the judge is finding that if this contract breaks down, URE is deprived of its very raison d'etre. We say that is an unimpeachable finding, and so it is not simply prudent and commercial, but is the only logical explanation that costs setting up URE's business were intended to be included within the scope of this clause. Unless your lordships have any questions, I believe that takes us to time.
Thank you very much, Mr. Woodward. Mr. Riley.
My lords, I've got a few hurdles to canter over, so I'll try and go as quickly as I can. On the sort of the wider points of principle, this is on ground 1A. Malen Friend's submissions along the lines that anything less than actual knowledge of the right, in this case the right of termination, makes no logical sense, because they say that just creates an unfairness, specifically because it removes a contractual right to terminate. But that's always the effect of a waiver. The doctrine of waiver involves a balancing out of the unfairness of removing a contractual right versus the unfairness to the counterparty. So I accept there is a loss of the right, of course, that's the effect. The question is overall which is more unfair, to allow the party to still stand on its right, notwithstanding an unequivocal communication to the contrary, or to still or to lose it. Now, in principle, we say there's no unfairness really here at all in circumstances where the waiving party has waived a right which is expressly set out in the agreement. On the contrary, it would be unfair to the counterparty if the right were not waived, and that the other party was simply allowed to not avoid the effect, as it were, of the right, purely because of a stated lack of understanding arising from a failure to understand, read, or take advice on it. And this comes to the point that my Lord Justice Mayles made in relation to the distinction really between a rule of law, which is obviously what we're advocating for here, that there's a deemed knowledge, versus an evidential presumption. And my Lord made the comment, well, that in relation to complex clauses, one can see that there might not be an understanding of the right in those circumstances. But taking back to the fundamental point here, even in the case of a complex contract with difficult clauses, the party has signed up to them. It's assented to that difficulty and agreed to the express rights or the express terms which create its rights. And in that particular instant, in that particular scenario, if there are more complicated clauses, but where the likelihood is that there's going to be a sophisticated party, no doubt with lawyers on board. But that particular scenario in my submission should not derogate from the stage one, which is the key principle that the parties have consented to the express terms. And they are taken to, or they take that contract as meaning whatever the court says it means, if called upon. And that takes us back to the point that was made by Ms. Justice Stephen in Sargent, which is that relying upon the Strange and Graucom, the party cannot say that the term is not in the contract. And I accept Lord Justice Miles' points that the Strange and Graucom is fundamentally about the content of the contract. But the point that Mr. Justice Stephen was making in Sargent was a two-stage analysis. Stage one is the party cannot deny the content of the contract, so it's taken to know that the clause is there. Stage two is that the party takes that contract as meaning whatever the court is likely to say it is when called upon. So in that stage two element, the party's subjective understanding is irrelevant because it's always taken to understand the clause as meaning what the court would say it would be. So it is not, and I apologise if my submissions were limited yesterday in this way, but it's not simply a question of content. It's a question of the clause having the meaning from the outset that a court would give to it. And the party is fixed with that and enters into the agreement consensually on that basis. That is the established position. Now, my learned friend suggests that the difficulties that arise here can be met by an evidential presumption. But in reality, in practice, that is a presumption which, in my submission, would be nigh on impossible for the counterparty to deal with. The suggestion is therefore that if there's an express term in the contract, the party is presumed to know it by that very reason, a fortiori. But all the party then has to do is to say, well, I didn't understand. Even if the party was legally advised, all it would need to do is say, well, yes, my lawyers told me this, but I didn't understand. So that leaves the counterparty with having to prove a negative, which it's never going to be able to do. And these are the difficulties, the inherent difficulties of this part of the doctrine of election that Mr. Justice Legacy was highlighted in Volnert, and Lord Pearson alluded to or expressly referred to in his judgment in Cammins, which your lordships have. It's page 878 of the Cammins report, Authorities Bundle, tab 10, page 246. Because there Lord Pearson was saying, well, if a party needs to know it's right, how on earth can it prove that? And if one then takes that to the next level of understanding, the task becomes even more difficult. And one can sort of test that in the context of this case, because the judge's findings in this case were along the lines that Mr. Ensor, on behalf of UAE, in order to know his right, would have had a precise and sophisticated level of understanding of the meaning of the clause. Not only the meaning of the clause, but how it applies in different circumstances. So,
wasn't he dealing with the point about legal professional privilege, Lord Pearson?
With respect, my lord, I don't think that's right. I think he's there dealing with the question of how is a party going to know and how can it be proved that the party doesn't know the right?
I think he was talking, wasn't he, about the problem that you get when lawyers are involved and then refusal to go into that on grounds of legal professional privilege. And he says, I do not think the law imposes on the tenant such an unreasonable burden of proof. He may be making a more general point, but...
Well, in my submission, he is making a more general point, because he then goes on to cite Matthews and Smallwood for the proposition that only knowledge of the facts is required. His conclusion is 878E. Party alleging waiver does not have to show the party alleged to have waived his right to appreciate the legal position. So in my submission there, Lord Pearson is talking about the nigh on impossible task that the counterparty faces if the requirement is for knowledge of the right. And as I've submitted, that becomes exponentially more difficult if one elevates the test to one of understanding.
The Court of Appeal analysed this case in Payman and Nanjani and reached the conclusion that it did.
Yes.
Having looked at all these passages.
Yes, it did, and Lord Justice Stevenson, in explaining the distinction between the various lines of House and Lord's authority, really, in my submission, used the lack of citation of Evans and Bartlam and Young and Bristol Aeroplane as explaining it all.
I mean, you may have a good point that Payman and Nanjani is wrongly decided, but they did discuss Cammins, and the passage in Lord Pearson, which you're showing us, powerfully reasoned as it is, does not, I think, depend on any distinction between express contractual rights and rights more generally, does it?
No, it doesn't.
So it doesn't really support the distinction you're urging us to make. It simply shows that one should confine Payman and Nanjani as much as is possible to do.
Yes, but on this specific point, my lord, I'm referring your lordships to it because it's a powerful description of the practical difficulties which arise when one has to apply the doctrine as requiring knowledge of the right, and it's a difficulty which in Involnert, as Justice Leggett as he was, says can be addressed in part, or mitigated, I think he said, in part by presumption of knowledge if there is legal advisors on board. But what can't be overcome in my submission is if with express terms there is a requirement to show that the party subjectively understands what the term means. But that is a task which is nigh on impossible, if not impossible, because it will always be open to the party to simply say, didn't understand, or yes, I asked my lawyer, but it was gobbledygook, I didn't understand. And that arises, that situation will arise from the fact that the party waiving has consensually signed up to express terms giving them rights and not taking the trouble to fully understand what their contract is. And that is, we say, an outcome which is unfair, and certainly more unfair than the unfairness alluded to by my own friend in his submissions. And it can't be an unfair result that the doctrine of election countenances. And I come back to my anchor submission, which is fairness is a founding principle of the operation of the doctrine. Just on this point, in
Well,
relation
there
to-
is a, I mean, some of the cases show there's a presumption where you have legal advice. I mean, could one take that further and say that unless it is displaced, there is a presumption that you know and understand what you've signed up to? And then the burden is on somebody who says, I didn't understand it, to come along and prove that, either by waiving privilege if he had lawyers, or by displaying his ignorance in the witness box.
Well, we would submit that there's a presumption, but it's irrebuttable in the sense that.
Yeah, I mean, I appreciate that's your case.
Yes,
of course.
yes.
But I'm just exploring the extent to which there are these practical difficulties, which you say makes the contrary submission unworkable.
Well, my lord, I would submit they are very real, and yet yes, in theory, if there's an evidential presumption, that's something that is open to the counterparty to deal with. And I say it's for the counterparty to deal with because it's very easy for the waiving party, whose subjective understanding is an issue, to assert in the witness box, I just didn't understand. And yes, that can be tested, but the practicality of that is that it's going to be nigh on impossible to dislodge that statement of a lack of understanding.
Well, you say that, but it may well be quite easy, actually. I mean, in the landlord and tenant cases, for example, if a landlord came along and said, I didn't know I had the right to re-enter, it's unlikely a judge would pay much attention to that.
Or a ship owner who says, I didn't know I had a right to withdraw.
Yes, or
any
an energy
Any
company,
number of rights.
or an energy company didn't know it had a right to terminate.
Well, that's rather different because that's a more specific contract. But there are categories of contracts, such as landlord and tenant, with which the court's familiar, where a judge would be pretty sceptical about a landlord coming along and saying, "This is news to me."
Sceptical, yes, but my lord, if there is an individual, a buy-to-let landlord, who's an unsophisticated person who's not used to dealing with leases, who turns up to court to say, well, yes, I have an express right of forfeiture in this lease, but when I signed up to it, I just didn't understand it. Surely the test there is, well, you're taken to understand it and know it because it's in your lease to which you signed up to, and if you didn't read it, you didn't understand it, well, then that is on you. And not something which should be underwritten by the counterparty. I was just going to take you briefly to, just on this question of understanding or knowledge, to the BDW and Roe decision, because there, on appeal, I'll take you to it in a moment, but the headline point here is that Lord Justice Patton was looking at the decision of the first instance judge, who had considered whether or not the alleged waiving party had turned their mind to the clause, had it in mind specifically, and understood it when the unequivocal act or conduct was being carried out. We've been looking at BDWs, and your lordships know the background, but the specific passage is that is Authorities Bundle, tab 25, page 753. and just to go back at one stage, page 752, your lordships will see reference citation to the first instance judgment, paragraph 126, where the judge refers to not turning their mind to the clause. And then paragraph 76, when commenting on the judgment of first instance, Lord Justice Patton says at paragraph 76 this: "It seems to me difficult to argue that Barrett, acting as it did, with the benefit of legal advice, did not have knowledge of the terms of the contract, and that a right to rescind had arisen as of 7th of July. Knowledge of such matters is not the same as actually applying one's mind to the question at some particular point in time." And he goes on, "The question whether a party with a contractual right to rescind has waived that right by electing to affirm the contract must depend on analysis of the terms in the particular contract and the circumstances in which the right has arisen." So there, in my submission, Lord Justice Patton is really applying a test not of understanding, but of the fact that the waiving party knows that there is a right, irrespective of whether or not they're actually specifically turning their mind to it. And whether or not there is a right, and what that means, depends on interpretation of that clause. And we say that is an entirely correct approach, consistent with what we submit is, and the approach that's in Sargent, which we submit is a wholly orthodox approach to contractual construction, and whether or not parties are taken to understand the meaning of their contracts. And then finally, just on this main point, and then Friend says that there's conceptual difficulty with what our case is, in the sense that on the one hand we're asking, or we're submitting that a right to terminate can be waived because it's an express right in the contract, but at the same time a common law right to accept a repudiatory breach and bring a contract to an end would not be. In my submission, there's no conceptual difficulty there. In fact, the distinguishing boundary is that in the former case there is an express right which is being waived and gives certainty, and in fact it ensures that the principle of the doctrine operates in a more narrow context. So in that sense, there is no difficulty with a party waiving an express right, but at the same time maintaining a different right because it didn't know that it existed. Just in the same way that there can be different breaches of contract, there can be different waivers in relation to the contractual rights. Moving on then to overlap with estoppel. Malone Friend's answer to the various problems which he says we create is that there's always a fallback of an estoppel argument. And in my submission, that's problematic for a number of reasons. Firstly, it's not very principled. It sidesteps the question as to how a separate doctrine of election should operate. And as the authorities we've seen, going through the authorities, have made absolutely clear, there are, and as the court obviously knows, there are important distinctions between the two doctrines. Election is concerned with what a party does and knows, as opposed to estoppel, which is dependent not on the knowledge of that party, but is concerned with what the counterparty does in reliance upon a representation. And so there are two different unfairnesses which are the subject or the focus of the two different doctrines. the unfairness in relation to election, which election seeks to remove, I should say, is not the same. It's an unfairness which lies in the inconsistency of dealings, which arises because of a choice made by the waiving party to prefer one right over another, and those are rights which are already supported by consideration. So, to my learned friend's point that there's no consideration involved here, in my submission, that is an inapposite analysis, because there's already consideration provided for the rights which support the contract. It's the unfairness which arises is that the party is preferring one right over another, leaving the counterparty not knowing where it stands. So that's why election brings down the guillotine in favour of one right over another. Whereas in estoppel, it's not a question of the party having chosen. It is a promise by the party not to enforce its rights in the future. And that's a promise which is unsupported by consideration, but is given effect to inequity because of the detrimental reliance by the counterparty. They're two very different. They come under the portmanteau of waiver, but they are different. They are different doctrines, of course, and those differences were highlighted, of course, by Lord Gough in the Cashin Junga. And for your Lordship's note, it's Authorities Bundle, tab 15, page 374, and by Lord Justice Ricks in Cosmar, paragraph 38, Authorities Bundle, tab 23, page 678. And we say that it's no answer to this question to seek to reverse engineer the doctrine of election by reference to a separate doctrine, common law doctrine of election, by reference to the equitable doctrine of estoppel. That, in my submission, is putting it the wrong way round. It's the common law principle, the doctrine that should be analysed first. And indeed, that is the sequence that Lord Justice May advocated in Payman Lanjani at page 493 G2H, which your Lordships have, Authorities Bundle, tab 14, page 355. So rather than just suggest there's a potential fallback under an equitable principle, the correct approach should be to define, first of all, how the common law doctrine of election should operate and what requirements it involves. Can I then just move now to the suggestion that there's some sort of special public policy for landlord and tenant cases? In my submission, there's no special policy made out. The judgments in Payman and Lanjani do not refer to any special policy in relation to landlord and tenant cases. Indeed, as I think Lord Justice Miles pointed out yesterday, Lord Justice Stevenson was at pains to make clear towards the end of his judgment that the principles are not limited to the principles he was talking about were not limited to cases of forfeiture. They were of much more wider application. He said that at page 487D to E of the report, which your Lordships have, Authorities Bundle, tab 14, page 349.
I see that, although I also notice that in the BDW case that you've just taken us to a little while ago, at paragraph 77, just after the paragraph you mentioned, Lord Justice Patten says that an acceptance of rent will necessarily have the consequence that there is a waiver of forfeiture under the lease, so that there is an immediate election to be made, and that sounds like a rule of law, not a point which is dependent on knowledge.
Yes, but Lord, in BDW, the focus of the court in that case was really on whether or not the conduct which Barrett's conduct amounted to an unequivocal communication of a waiver. And so that comment in my submission was really aimed at or highlighting the unequivocal nature of acceptance of rent. It's clear from that conduct that there is an upholding of the lease, and so he doesn't there refer to special policy in relation to landlord and tenant. I'm sure Lord Justice Patton, if he'd had that in mind, would have spelt it out. But he didn't, and really his thinking there, his reasoning there in my submission is along the lines to say, well, certainty is required in relation to leases, and of course it couldn't be said that there's no waiver if a landlord accepts rent, because that is the clearest possible indication a landlord can give that it's affirming the lease. And this comes back to, or takes me to my broader position here, submission here, which is that the cases dealing with landlord and tenant, which really in my submission start from Matthews and Smallwood, are all based on the principle of election. In Matthews and Smallwood, the court was dealing with analysis of election. There was no attempt to simply, as a sort of deus ex machina, sort of just apply some rule of law that specifically applied to landlord and tenant. The decision was based on the principle of election, and your lordships see that quite clearly. We've already seen it, but it's quite clearly at page 786 of the report in Matthews and Smallwood, on page 139 of the authorities bundle. Tab 5 should add. And Matthews and Smallwood obviously was a landlord and tenant case. It was not. There was no part of the reasoning was that, well, to say that we are dealing with a special type of contract, and therefore this is the unwritten rule in relation to landlord and tenant cases. And equally in relation in payment, at page 482H, when Lord Justice Stevenson was explaining the decision in Matthews and Smallwood, and he says that the lessor is taken to know of the rights that are expressly given, provided by the lease. There was no reference there to a particular rule which treated landlord and tenant cases in a special way. And as that's already submitted, that must be right, because he went on to say that that the principles are not peculiar to forfeiture of leases. And his focus was the question of knowledge, and whether or not knowledge must be taken because the rights are set out in express terms. And he's, in my submission, quite clear when he says that the lessor must be taken to know because they are express rights. And as we've already seen, Matthews and Smallwood was not based on a particular rule for landlord and tenant. And your lordships will have very much in mind that in Payman Lanjani, Lord Justice Stevenson was trying to navigate his way between two lines of House of Lords authority. No easy task. But in doing so was looking for levers to pull in order to distinguish between the two lines of authority. A very obvious and easy lever to pull in my submission would have been to say that Lord Pearson was wrong, or insofar as he was right, it was because he was relying upon a landlord and tenant case, and of course there is a particular rule in relation to landlord and tenant cases, but Lord Justice Stephen did not say that. He did not distinguish Lord Pearson's judgment on the basis of being limited to a particular form of contract, i.e. landlord and tenant. So, whilst obviously there is a need or certainty in relation to leases, because a tenant runs the risk of potentially being a trespasser. That is in principle no different to the certainty that contracting parties crave in their dealings going forward. An insured would want to have certainty that if the insurer was receiving or was giving signals to suggest that the claim was going to be entertained, the insured would need to know where it stood in relation to the policy. Equally, an insurer could not say that a delay in relation to submitting the claim was something that they weren't aware of. But these are all important points integral to the contractual relationship between these parties in that particular instance, which the parties need to have certainty about. So this is not a principle which is confined purely to landlord and tenant cases. Just on, finally, before I leave Payment Lanjani, and just to pick up on what my learned friend said in relation to the right that was the subject matter of that case. I think we're there in terms of identifying it, but for your Lordship's notes, in Payment Lanjani, you'll recall that Mr. Payman went to a second set of solicitors because he was, quite frankly, fed up with the shenanigans of trying to complete the deal, and those solicitors wrote a letter for action. That's set out in page 472, and at 473 F to G, various misrepresentations were sent out, including representation based on referring to the impersonations. Then the next part in the sequence is that, in fact, in the case, the landlord had agreed to grant a license, which it was holding and was sealed and ready to exchange, and urged Mr. Payman to complete. So that makes it clear that condition 9, the national conditions of sale, was not being relied upon at all, because there was essentially consent for the lease. There was license for the grant of the sublease.
I think that was only after the date of completion. I mean, the ultimate decision was that there was this defect in the title, which was to do with the first impersonation, because it was the way that the defendant had got hold of the lease. And the Court of Appeal said that where there's a defect of title of that kind, that gives a right to rescind the contract, even where you've got into possession if you don't know about it.
Yes.
And that was, I think, the ultimate decision.
Yes, and
I think you're right. It doesn't. I think in the end, it didn't turn on clause 9.
Yes,
on the exercise of clause 9 right.
And my lord, just to top this off, if I may, it's put beyond doubt in my submission by Lord Justice Slade at the bottom of page 497 of the report, so it's page 359 of the bundle. He says this: the crucial question, however, is this: did he, as the judge thought, by taking possession of the restaurant and paying the £10,000 on the 22nd of February 1979, lose his right to rescind on account of the undisclosed latent defect? And that's the latent defect of the first defendant's title. So that in my submission, that makes it absolutely clear that this was not a contractual right that was the subject matter of Payment Lanjani, but a common law right to rescind because of a latent defect. My learned friend referred to TCG pubs and the girdlers. Just a quick comment in relation to that, my lords. That was the decision of Mr. Justice Mann. In my submission, it takes the matters no further forward, because in that case, Mr. Justice Mann found there was actual knowledge at the meetings between the landlord's solicitors and the landlord. And in that case also, which was, interesting enough, a a lease case. The question of whether or not knowledge of the express terms is deemed was not raised, and equally no point was taken that because it was a lease, the lessor was deemed to know its rights. So it really doesn't advance matters any further for your lordship's determination in my submission. Coming then to ground 3, which is clause 10.5. Your lordships have my key submission on that, which is that it's not the remaining value of the contract, but it is the remaining, or not just that, it's the remaining value of the contract to the supplier. So my learned friend Mr. Whibley was referring to the value of the contract as being essentially the contract price, the amount that would be payable over the contract. But that is not the same in my submission as the value of the contract to the supplier. And the second point I just want to briefly make, which is an important point, all the same, is that it is the value of the contract. It is not, and when we say that means profit generated for the remaining period of the contract, that is the profit only in relation to the contract. That is the supply of electricity over the remainder of the term, the cost of that versus the income to be gained by that supply. Questions in relation to the overall cost of URE setting up its business for a potential long-term contract, which NHG was not bound to give, do not come in my submission into the equation when one is looking at the value of this contract for the remaining period of the term. So, and on the point that this was always intended to be a loss-making contract, well, it may well have been as a matter of fact, certainly on URE's side, that they didn't anticipate that they were going to be making profits. But there was nothing to suggest that this was always intended by both parties to be a loss-making contract.
Sorry, don't repeat that point.
There's no evidence to suggest that this was intended by both parties to be a loss-making contract. And you were taken to various parts of the pleading. But our position was that we didn't admit the figures that were being advanced in relation to the loss of profits claim. In fact, and so from NHG's perspective, we simply had no visibility on the figures. We didn't know what profits were going to be made or losses could be made. And we make that admission in paragraph 45, subparagraph 3 of our defence, and that's core bundle 258. So I reject the submission with respect from learned friend Mr. Whibley to suggest that we somehow admitted that we knew that this was all along going to be a contract which would not make any profit. That leaves me in the remaining 3 minutes to deal with the procedural objection to ground 1A. I think I've already outlined to your lordships what our position is on that. We say that it was available to us on the pleadings. And I need to take your lordships to that. It's paragraph 15.9b(1) of the amended defence and counterclaim, which is at page 241 of the core bundle.
Right, well, at least you agree the same provision is relevant.
Yes. Yes. So we say there that knowledge was established because the right was set out in an express term of the contract. And then if we look at how that is dealt with in the reply, which your lordships will have paragraphs 27C and E, core bundle page 279. this is responding to our allegation that knowledge arises because there's an express term in the contract. And the response is, well, there has to be actual knowledge. And then in E, it's pleaded that there was a lack of awareness because it was not as a matter of fact aware of the contents of the clause. And then a few lines down, insofar as is necessary, it's denied that constructive as opposed to actual knowledge of clause 10.2d is sufficient. Well, implicit in that, in my submission, is basically a defence to say that, well, just because there's an express term setting out the right doesn't mean to say that we have knowledge of it. I've given to your lordships in our written submissions at paragraph 41. In our supplemental skeleton, I should say, in paragraph 41, the various parts of the written submissions, both opening and closing, and the cross-examination where we say we put this point. But in any event, we say that the real answer to this particular point lies in the judgment of paragraph 128. On page 178. And it's the last 5 lines. Judge held, the fact that the contracting party may be contractually bound by the terms of the contract which it has not read does not mean it's fixed with knowledge of each and every term for the purposes of waiver by election. We had raised the Strange and Graukob in submissions, both written and oral, to make the point that if there's no knowledge because despite there being express term, that is very much at odds with the established principle of being bound by express terms. And this part of the judgment shows that the learned judge understood the point we are making to the lordships today was being made to her. And indeed, that is the part of the judgment which we say is an error in law. My lords, the bell has tolled. That
Well, the bill has told, but I take it you have made the points that you wanted to make.
my lord, yes, I think it was just in relation to the additional grounds of my learned friend. I think your lordships have my point on that, which is I endorse the interpretation of clause 10.2 at any time. If I may, just very briefly to say that learned friend relies upon the analogy with break clauses that were referred to in BDW. As I think, as my Lord Justice Mayles observed yesterday, that analogy is not apposite here because with break clauses, as Lord Justice Patton held in BDW, the existence of the break clause was not inconsistent with the landlord and tenant relationship. So the fact that a break clause could be exercised at any time did not present a fork in the road between terminating or affirming. And indeed, the actual clause in BDW could not have been exercised at the time that that Roe had said, because there was no entitlement to exercise the right because Barrett was still potentially in breach of clause 6.2. So for those reasons, I say that in fact BDW supports what we say, which is that where you have a right of termination, that is a fork in the road, which is inconsistent potentially with, if the right is exercised, with the contract subsisting, and therefore we're not in that sort of that territory of a break clause which can be exercised at any time. Clearly, this was a clause which was not dealing with affirmation, and your lordship's point was a good one in my submission when you asked my learned friend, well, does he accept that if there is, notwithstanding the clause, an affirmation, that effectively is an affirmation for all purposes? That was the point that was made in Telly 2 by Lord Justice Aikins, and that's the line of authority and reasoning that was adopted by Mrs. Justice Mulder and the judge below in this case. So, Lord, I really have taken liberties now, so I'm sorry for gabbling beyond time, but those are my submissions, and I fall back obviously on my written or our written submissions as well.
Yes. Well, we'll reserve judgment. We'll give you. We'll send a draft judgment to those whose names have been provided. That will be confidential and subject to the embargo until such time as it's handed down. You know that we take that all very seriously. We will hope and expect that in the light of whatever we decide, you will be able to agree a draft order to reflect our decision. If you find that you can't, we'll have short submissions in writing and resolve them without a further hearing. So it only remains to thank you all, those who have spoken and those who've been in a supporting role. We're very grateful.
Thank you, Lord.